Hi, welcome to another episode of Estate Planning with Eugene. Today, we are very honored to have some special guests in the house. But before we do that, let me just explain to you some of the key statistics and some of the key background for most of you here. According to the Department of Foreign Affairs in Philippines, we call it the DFA, in the year 2022, an estimated 200,000 Filipinos live and work in Singapore, and they actively contribute to the economic development of both the Philippines and in Singapore. Approximately 60% of these Filipinos in Singapore are working professionals and skilled workers, while the rest are employed as household service workers. There are also an estimated about 46 Filipino-owned enterprises operating here in Singapore. So in this episode, we are so honored to have Zandra and also Danny, who are associates and senior associates, respectively, of Couple Law, a specialized law firm with expertise in corporate tax, estate planning practices, amongst others. Today, I have actually invited both of them, who are so busy, to take time off to discuss with us about inheritance and estate distribution, and what happens if you have assets both in Singapore and also in the Philippines. Hello, Zandra and Danny. It's great having you guys here with us. Why don't you tell the audience what you exactly do and your area of expertise? Zandra, over to you.
So hi, I'm Zandra. I specialize in corporate and tax laws, and I have handled wealth and succession planning with some of the Philippines' top business magnates.
Do you mind to share one of them? No, I'm just kidding. Danny, over to you. What do you specialize in?
Hi, Eugene. Thanks for that introduction. I specialize in commercial, corporate, and tax practice. In line with today's discussion, I do also handle estate settlements and estate planning for some of our local and foreign investors here in the Philippines.
Great. So both you guys are the tax people. You know anything about tax, you are the experts. Now, can you just give us a very quick overview of the Philippine tax laws? I heard that there are two different levels. Do you mind sharing with us that?
Right. So there's basically two types of taxes in the Philippines. First is national taxes and then local taxes. Today we're talking about estate taxes, which falls into the category of national taxes. Estate taxes basically comprises of three types of decedents.
Okay.
First is the non-resident alien decedent. These are foreigners who have assets here in the Philippines, and their gross estate basically comprises only of their assets in the Philippines. The second one would be the resident alien decedents, which their gross estate basically comprises of the entirety of their worldwide assets. There would only be deductions with regards to their assets which are situated in other countries that would be subjected to foreign laws. And then the third one is the residents of the Philippines or citizens of the Philippines, which gross assets are based worldwide. Wherever they are in the world, their national law governs in the distribution of their estate.
You are saying that there's actually, on a national tax level, there are three categories, right? The first category would mean foreigners, basically non-resident alien descendant, foreigners who have assets in Philippines. So if let's say I am actually living in Singapore, but I purchase a property in the Philippines, I would be part of category one. Is that right?
That's correct.
The second group, you were saying that it's based on the resident alien descendant, which means that it's the PR, permanent residents, who are living in Philippines, but they are not a citizen. In terms of taxes, the entirety of their worldwide assets, net of those that have in the Philippines,
yes, correct,
would be part of the estate tax.
Right.
And of course, last but not least, how can we forget the Filipino citizens, means those who are working, who are living in Philippines itself. This group of people, basically their entirety is a worldwide assets, would be subjected to the estate duty in the Philippines. So can you give us an example? Let's say John, let's call this client John. He's an American citizen. At the same time, he's also a resident in the Philippines. So he owns assets in Singapore and in the US. And of course, he owns a little bit in the Philippines. Okay, so John is an American citizen. He actually lives in the Philippines. He has some assets there, but he also has properties in the US and has some in Singapore as well. So in this case, will all three countries' assets be computed at the gross estate, And how does it? What is the way how Philippines treat his Philippines assets?
So if John is a resident of the Philippines, basically, so his assets from the United States, Singapore, and the Philippines would form part of his gross estate. So everything would be included in his gross estate. And then those that are not subject to Philippine laws, which are those properties in the US and Singapore, would be deducted from this. And that's where they'll get the net estate. That would be subject to the 6% estate tax here in the Philippines.
Okay, I see. Now, let's move on to the next example. What about Mary, who is a Filipino citizen? Okay, she's actually in Philippines. She owns assets here in Singapore and also in the US. In this case, does it mean because she is a Filipino citizen, all the assets that she owns worldwide, in Singapore, in US, and these two countries, and even in the Philippines, all these will be considered as part of a gross estate. Is that right?
Yes, that's correct, Eugene.
So that's the difference. So there is no deduction of Singapore and US assets because they all follow the Philippines law.
Yes, exactly.
In other words, in category 3, Mary is being domiciled in Philippines and therefore everything follows the Philippines law.
Mary, as long as she's a Filipino citizen, wherever she is, might she be in Singapore or the US, as long as she's a Filipino citizen, national law governs her estate.
Okay, I would like to ask this question. All right, it's very common amongst most estate planners and clients. Like, how would the Philippine government know that this client, this citizen has assets maybe all over the place? Like, how would the government know? Do you get this question all the time?
Yes, we actually do. With regards to the estate of a person, if they have heirs, it depends. Do they have a will? Do they not have a will? So if they do have a will, there's a presumption that they would list every asset that they have before they could distribute this. So a will is subject to probate. They need to go to court to check on the validity of the will. So this is how the government would know if they have assets elsewhere.
And Zendra, that's a very good answer. You mentioned that in the areas of filing for probate, filing for the court procedure, if they have a will, they would have stated every class of assets that wherever. But what if, let's say, this individual doesn't do a will?
Right. If they don't have a will, usually the heirs, they would know what are the assets of the decedent, but they need still, if they need to distribute this in a very efficient manner, they need to make an extrajudicial settlement. This settlement, you don't need to go to court, but you need to have it notarized. You need to have basically a lawyer to authenticate it.
But must it be done in Philippines? Like, for example, if I'm a Filipino and I have an asset in the US, right? In the absence of a will, my heirs wants to go to the US to redeem and to close that account. Does it need to go through the notary public in Philippines, or there is no need? You can go direct to the US to get that resolved.
Okay, if you're talking about bank accounts, there is no need. It's another circumvention of the estate tax. You can directly go there, because it would really depend on how this US or American bank would release the funds to you as the heir.
So if there are assets that do not require, let's say, the notary public in the jurisdiction, let's say in the Philippines, to endorse, and then that, in that sense, would have not be in the radar, right, of the Philippines government. Is that right?
Right, that's correct.
Okay, so that there is a small blind spot. Maybe we should not keep this in the filming, because I don't know whether is it against the tax authorities in the Philippines or not, but well, this whole recording is to give information. Okay.
There's always a loophole,
Great. Okay, let's move on. So what is the tax rate, or I would say the estate duty, all right, in the Philippines? What is the tax rate like, and are there any deductions, any way to reduce? Why don't you share with us more about this?
Okay, so there is a standard deduction of 5 million pesos. In Singapore dollars, it's 121,000. This was actually increased in the recent years with the effect of the train law. Before the train law, it was just 1 million pesos. There's also a deduction with regards to the family home. There could only be one family home. Your estate could also be deducted about 10 million pesos for the family home.
So if you have a home, you can only have declare one home. In total, you can have about 350,000-60,000 of exemption. Is that right?
Yes, that's right. And then above that would be subject already to the 6% estate tax.
Oh, 6%. Has it been going down, going up over the last couple of years?
It's actually been just flat graded. The recent years, it has a graduated scale from 5 to 20%. It depends on the net estate of the decedent, but because of the train law, it is now a standard 6%.
Okay, so it used to be between what, 5 to 20?
5 to 20%, depending
on the progressive tax rate.
Yes, there is a graduated rate. That's right.
Wow. And since when it has actually stayed fixed at 6?
Since 2018.
2018. Oh, that's a big improvement, right? I'm just thinking for the wealthy people, they will be laughing from year to year, right? 20 to 6%.
Right, that's correct.
Okay. Is that the reason why perhaps the government is doing to attract foreign investors and foreigners to come and stay put in Philippines?
Yes, that's why the train law was enacted, was for the Philippines to entice foreign investors.
6%, you're talking about the US at 40%. This is like really more than half of that tax rate. Well, maybe this is a good destination for retirement as well for many of the listeners here. So 6%, that is in excess of about 360 Sing dollar. Does this 6% apply to both Filipinos and also or foreigners? Is it the same flat 6 throughout, regardless of the categories you belong to? Remember, we talked about the 3 categories.
Yes, you're correct. It applies to the 3 categories.
So what about some deductibles? Like for example, if I have a property and I'm still paying a loan, do I being taxed at just the net equity, less of all my liabilities? How does that work?
So those are actually also deducted from your gross estate. Claims against the estate or debts and unpaid mortgages, those should be deducted from the gross estate because you need to pay it first before you distribute the net estate to the heirs.
Okay, fantastic. And by the way, the taxes are paid to similar to like what IRAS in Singapore, the Inland Revenue Authority, to the BIR, right? To the BIR in the Philippines.
Yes.
I do get friends asking me that, hey, in some of the countries, even you don't pay the estate duties, you are fined, the assets get released quickly. But how is it like in the Philippines if someone doesn't pay their estate duty? Well, is the government going to go after them? Is there going to be frozen in the assets? How is it like in Philippines?
Maybe I can shed some light on this. Generally speaking, you cannot inherit the properties from the estate without settling first the estate taxes. So it will be difficult to transfer them because the BIR the tax authority is going to issue what they call a certificate authorizing registration, or the CAR, in order for you to transfer properties of any value from one person to another. So this includes properties that will be transferred through inheritance. So you first have to go through the payment of the estate taxes before the net estate can be distributed to the heirs.
The BIR is the one that will either facilitate or store the whole process of the transfer. But help me to understand.
Yes.
In order for the family heirs or the beneficiaries to have money to pay for the estate taxes, they need to first have access to the money, right? To the bank accounts, to the insurance payouts. So isn't it a chicken and egg where, you don't give me the money, but you're asking me for money? How do most of your clients resolve this?
Okay. So actually in that instance, there's maybe 2 remedies that we can provide. So in some cases, what clients would do is if there are multiple properties that were left behind by one of their parents who passed away, you can actually settle through piecemeal settlement. So meaning to say you can settle first maybe the first property that's the largest so that you can get the money and then use the proceeds to settle whatever other liabilities there are, taxes and other claims, so that you can also use that to later on settle the estate for the other properties. Another would be some clients have bank accounts that are reserved specifically in preparation of settling estates.
Ah, okay. Because bank accounts, are you referring to like joint account holders?
Some of them are joint accounts, some of them are just specific single account holders. So, but it's good that you mentioned the joint accounts because that's actually a better account to have in preparation for estate
Okay,
settlement.
right. So the tip here is in order to ensure that our beneficiaries don't go into a negotiation, a piecemeal negotiation with BIR, and to have enough finances to pay off your estate duty to release the assets, it is highly advisable for clients to set up a joint bank account with their family members and reserve some money inside to be paying for the estate taxes. Is that right?
Yes, that's correct.
Thank you for the tip. Now, talking about bank accounts, I also understand in the Philippines there's something very exciting and something very unique solely just in the Philippines. Do you mind sharing with us how interesting about bank accounts is in the Philippines?
Well, for bank accounts or bank deposits, these are actually also subject to the estate taxes once the account holder passes away.
Okay.
So the moment that the account holder dies, and let's say his heirs have the complete documents and they want to withdraw already the monies in that bank account, the 6% will already be withheld by the bank as part of the estate taxes, and they will pay it directly to the BIR.
Wow. So the bank is in cahoots with the BIR. Yeah.
Well, they're acting as the withholding agent.
The bank basically is the most efficient. In the entire collection, the bank is the most efficient. So what happens if it's a joint account, right? Let's say I have a joint account with my partner and I pass on first. And in the bank account is 100,000. Will it be 6% of the 100,000 or will it be 6% of maybe half of it?
So if it's a joint account, and there are two depositors, right? And one of them passes away, only half of it will be subjected to the 6% estate tax.
Half. And I believe the bank doesn't bother whether if the money belongs to me or to my partner.
No, because the bank actually doesn't have a way of knowing if you're the one who generated the income, as long as the account is under both of your names. So the presumption there is both of you own them.
So it'd be quite sad, right? Like imagine, okay, that I have a bank account with my partner and I put all the money inside. And then for some reason, my partner goes off first. Everything is my money. But because I put my partner as a joint account, the BIR is going to charge 6% of half of the amount inside. And it's quite sad, right? So do you get clients complaining or find a way out over this whole joint bank account thing in the Philippines?
Yes. So another interesting way to maybe work around it is if you're going to set up a joint account, make it what we call an and/or account. So there's two types of joint accounts, joint bank accounts in the Philippines. There's the and/or account and there's the and account. So this is mainly regulating the number of signatories that banks require. So for and accounts, they will require both or all of the named depositors. If there are 3 depositors, then all 3 of you have to sign. But in the case of the and/or account, just one signature would be sufficient. So what would be a good idea maybe is you could set up a joint account, which is an and/or account. And later on, if there's already this inkling that maybe one of the depositors has a terminally ill condition, maybe he's in the ICU or suddenly had a fatal accident, then you can easily withdraw the amounts and use it for either hospital bills or maybe later on if he passes, you can already use it to settle the estate.
So what you're trying to say is that have a and or, so that if you know that your bank account holder is going to pass on very soon.
Yes.
Before the BIR comes in.
Yes, that's
you
correct.
quickly withdraw the money, or am I allowed to say that before the BIR comes in? Okay.
Yes, otherwise it's going to be 6% less later on.
Okay, help me to understand this. If let's say the surviving joint account holder is not fast enough to react, how fast is BIR? Let's say today is the the death of the individual and he has a joint account,
Mm-hmm.
how many days or weeks are we looking at where BIR comes in?
Oh, okay. So actually, the BIR will not know unless they are notified.
Okay.
But it's the bank that will have a stricter regulation that if they find out one of the depositors has already passed away, they're going to require additional documents, such as, is it the executor who's withdrawing the amount? Is it one of the co-depositors? Is it one of the heirs? So they're going to look for proof saying that you have the right to withdraw those amounts.
Okay, so even if it's a joint account, as long as the bank understands that one joint account has passed on, it's not so easy for the survivor to withdraw money. Is that what you're saying?
Well, if the survivor is one of the depositors, one of the co-depositors, right, the bank will not have that many questions because you're technically one of the owners. So you can still withdraw it even after, let's say, a day after your co-depositor has passed away.
Okay.
But once the bank has been notified that the other person has passed away, then the 6% will be withheld.
I understand. So in that sense, the joint account holder who is surviving can still wait for a few days, and he or she does not need to do the withdrawal before the person pass on. But it's best to do that.
Yes, it would be best to do it before, but if it cannot be avoided, then you have a few days, yes.
Okay, understand. Now, so that is so much for bank accounts. I hope all of you are still enjoying. Those who are listening in while watching this video, now you know how to advise your clients who are people from the Philippines, who have joint bank accounts. This is how you can actually advise them. Now, I'm going to quickly switch channel right now because, we have started the whole interesting topic about having said that there are rising number of Filipinos that are coming into Singapore to work and even to start a family, eventually maybe to get a PR or even citizen. So I'm just very curious because, personally, I have a friend. She may be watching this. She's a financial services manager. She's a Filipino, but she's converted to a Singaporean. Right, so when she does that, she's a Filipino, but she's now here in Singapore, working here. Okay, now what will happen to the assets when she's gone? But let me give you two different scenarios. Number one, if this Filipino is in Singapore but is not converted yet, versus the one that is converted to a Singaporean. Can you share with us the first scenario? A Filipino here working, but pass on. Now, what is the estate tax and how does the Philippine government see this?
Okay. To properly address this, so the first scenario is when she's still a Filipino citizen. Am I right? Okay. So as we've said earlier, if she is still a Filipino citizen, although she's already in Singapore and she's been a resident in Singapore for quite some time, her gross asset would basically be her assets in Singapore and the Philippines and wherever she has other assets in the world. This is what would comprise her gross asset.
Okay, so if she's still a Filipino
citizen, yes.
Citizen just working here in Singapore, actually everything inclusive of Singapore assets will be under the 6%.
Yes.
But the difference, if I'm not wrong, is that the Singapore banks will not deduct the 6%, right? Because it's up to the... Okay.
Right.
Okay, so what if, let's say, this individual has turned to be a Singaporean, scenario number 2. Now, so, being a Singaporean, I'm sure the Philippine government will have a different treatment, right? So how does that work out?
Okay, if you're already a Singaporean, if she's already converted into a Singaporean citizen, then her national law or Singaporean law applies. As far as the Philippine law is concerned, there's no estate tax.
Okay. So that's perhaps one of the reasons why my friend converted to a Singaporean, because of that 6% that she has to pay. Well, so you are saying that the moment where somebody gives up the citizenship, he or she is no longer subjected to the 6% estate tax.
Right, because with regards to citizenship or being a decedent, it's the national law of the person which is the main source or basis of estate tax.
Perfect, perfect. Well, so much info for all our guests trying to learn more about the Philippines law in terms of estate duty, estate taxes. Now, we have not talked about one very interesting topic that most of our listeners will definitely want to know is what is the Intestate Succession Act in the Philippines? You know, in Singapore, we call that in the absence of a will, then there is always a default will that comes in, right? The government sets the will for you. How does that work out to be in the Philippines if someone passes on without a will?
If a person passes on without a will, we call it an intestate succession. So that is going to be the rule that would govern her estate. With regard to intestate succession, what's important is, does he have or she has any heirs? As a rule, descendants would exclude ascendants. So as long as he or she has a child, then her parents no longer would be her heirs.
As long as somebody in the Philippines has no will, has a child.
Has a child, yes.
As a child, the family member, the parents,
yes,
will not be included.
Already excluded from being
excluded.
here. So here in the Philippines, what I've heard is that in Singapore, illegitimate children cannot be heirs. Is this right?
In Singapore, the children can be heirs as well.
Illegitimate children.
Illegitimate cannot.
Yes. In the Philippines, illegitimate children can still be heirs, although the portion basically of the assets that they would gain is only half of the legitimate heirs.
Oh, okay. So illegitimate would have a share under the intestate succession, but only half of what a legitimate child.
Exactly.
Is there a reason why the law favors the illegitimate child? Is there a reason? Is that a lot of cases like that?
Well, we can only assume that in the Philippines, every child is, everyone that is a child has a parent. You know, there is only a discrimination with their status, illegitimate or legitimate, but otherwise there are still children of their parents.
But I do see an issue in verifying the illegitimate child, right? Like, how is the family going to vet through, like, are you the illegitimate child and who do you come from? You know, like, is there a hard time? Are there a lot of cases of lawsuits to even dispute?
There are actually several lawsuits here in the Philippines regarding filiation or paternity, establishing paternity specifically. So there have been instances where a child would claim to be the illegitimate child of one father, when in their birth certificate, they have a legitimate father. So it gets kind of confusing. But yes, there are several cases of that happening here. And I guess one of the reasons why the succession law is the way that it is, well, they want to encourage Filipinos to just have legitimate children. But indirectly, what they're doing is they are actually punishing the illegitimate child who had nothing to do with how he came here in the world. So it's a bit strange, but yeah, that's how it is.
I do see a higher chance of a motivation of why somebody should have a will, right? A Filipino should have a will, so that you can express your interest, whether you want to give to the legitimate, illegitimate, and how much. It is a greater motivation for somebody to do that. Is that right?
So in terms of the amount that you can put into the will, yes, you do have a sense of freedom, but only half. So there's still what we call under Philippine law the legitim. So there's two portions into the estate of a person who passes away. Half of it is called the legitim, which is, under the law, mandatory to be given or distributed to the forced heirs. The other half is what we call the free portion. So the free portion can be given by the testator to anyone he wants.
Yeah, coming to that, we will actually be covering the concept of forced heirship in the Philippines, which is a very exciting topic. So just let me sum up this section first. We talk about the intestate succession in the Philippines. We are talking about in the event if there's a spouse and there's a kid, right? There's a spouse and a kid, including illegitimate. Then they will split into equal shares, right? And we are talking about if there's no spouse and children, okay, then what happens? If there's no spouse, no children, who will get the money?
Okay, if for example, there's no spouse, right? There's no legal spouse, there's no legitimate children, no illegitimate children, but you still have your parents. Your parents will get your money.
The parents will get. But if you have no spouse and only children, then the children, which is inclusive of the illegitimate, will receive all the money. So the hierarchy is your spouse, your kids, then your parents.
Not necessarily. So it's a bit more complicated here in the Philippines in terms of the succession laws. So like Attorney Zandra mentioned earlier, the general rule is the descendants will exclude the ascendants. But at the same time, if you have a legal spouse and if you have illegitimate children, they also come into the mix.
Okay.
And then there's specific portions dictated by the law. If, for example, you have a surviving spouse at the time that you passed away, at the same time, you have your parents and you have illegitimate children.
Wow.
No legitimate children, okay? What happens if that's the scenario? All of them have a share in your estate.
I see. Okay, interesting. Now, thank you for that. That's all about the intestate succession, which are very different, right, from what we are used to in Singapore, especially the illegitimate child. Okay, so coming back to the concept of the forced heirship, could you kindly explain more about this forced heirship in the Philippines?
Okay, so forced heirship in the Philippines, basically the law dictates who are the persons who are entitled to shares in your estate. So they're the ones who get to have a part of what we called earlier as the legitim, or the mandatory portion that has to be distributed to them. The forced heirs have a specific order wherein they will inherit. So first are the legitimate children. If you have legitimate children, then they're first in line. If you have legitimate children and a legal spouse, then they all get a share. If you have legitimate children, a legal spouse, and your parents are still alive, your parents won't inherit anything. It all goes to your children and to your spouse.
Right.
If you have legitimate children, have a legal spouse, and you also have illegitimate children, this is where the portion that Attorney Zandra mentioned earlier, that your illegitimate children, no matter how many of them there are, all of them, for example, there's 5 of them, right?
Yeah.
And you have 3 legitimate children, so you have 8. The 5 illegitimate children will only get half of what one of your 3 legitimate children will get.
When you talk about forced heirship in this order, are you saying that an individual can write a will to circumvent and to overrule this forced heirship? Is that possible? Let's say I'd like to write a will 100% to give to my friend. Can it be done? Is it legal?
100% to your friend, it cannot be done because, like I said, there's 2 parts to your estate, right? There's the portion that has to satisfy the legitim, and then there's the free portion. If you're going to give all of the free portion to your friend without impugning the legitim, then that's okay.
That's okay.
But if what you're planning to do is give all of it to your friend, then that cannot be done.
So what is the percentage of my inheritance that is under the mandatory forced heirship?
It's 50%. It's half of your estate.
Okay. In other words, for a Filipino to write a will, it can only be 50% of what they have to give to whoever. It's free will.
Technically speaking, yes.
So are there clients that find ways and means to circumvent this forced heirship? Is it common?
Well, in terms of writing the will, there's not so much leeway around it, because if you do write a will, it's going to be subjected to the probate of the Philippine courts. So they will find out if you complied with the requirements of the law in satisfying the legitim and the free portion. If they found that whatever you wrote in your will doesn't comply with the law, then they will most likely rule that your will is invalid and your whole estate will be distributed as if there was no will in the first place.
But if, let's say, somebody does a will and they distribute their assets to their children and their spouse, then it can supersede the forced heirship because you're giving to them.
In a way, yes.
Okay, I got you. So a will is still possible to be 100% of what you have, but you need to make sure that the beneficiaries are based on the forced heirship listing of benefit, right?
Yes, that's correct.
Fair enough. Okay, that's fair enough. Thank you so much for both of you, Danny and Zindra, who has been helping to us to dissect the complex tax laws in the Philippines and sharing about, how a Filipino who is working in Singapore, whether or not it's just for a time being or even long term as a converted Singaporean, and how would the Philippine tax laws apply. I have just the last one or two final questions that I have for both of you. When you talk about the first scenario, 6% applies to assets only in the Philippines. That's for foreigners. Right? Foreigners with assets. 6% applies for only assets in the Philippines. Let's say we are living in Singapore, we are not a Filipino, and my parents from the Philippines left me assets, maybe properties, cash, and whatnot. What will happen to those assets?
In this scenario, it does not matter whether you are a Singaporean or a Filipino citizen. What we're talking about is your parents' estate. So the estate will be subjected to the 6% estate tax.
So it depends on the deceased, right? Whether he's a Filipino, a citizen, or he's a foreigner, based on the three categories we defined earlier.
Right, correct.
So let's say there are Filipinos and they deduct the 6%, everything comes to me, there's no more taxes already.
That's correct.
Okay. If, let's say, my parents own real estate in the Philippines, can I, who has converted into a Singaporean, can I inherit real estate in the Philippines?
Yes, actually. There's actually a prohibition of foreign ownership on land under Philippine laws.
Yes.
But by way of exception, if you inherit the land, then foreigners can actually inherit land here in the Philippines by way of inheritance.
Right. So for foreigners, we are not allowed to own land in the Philippines. But if it's in the form of inherited land, it's fine.
Is
there any special taxes, or I don't know, is there any things we need to pay to own that piece of land as a foreigner? Is there a cap?
No, there's no tax to be paid as long as it's inheritance. So the assumption is there's already the 6% paid of the estate tax. The distribution would be not subject to any more other taxes.
Okay. Now, finally, we come to the end, and I just want to know, because this is also the interest of many of our audience, and even for people listening in, they want to know, so 6% is not high compared to the world, but are there any ways that we can go around so that we can minimize the taxes, the 6% estate taxes? Can we minimize? Maybe there's a concept of a trust, also the concept using life insurance policies. Both of you, Danny and Zendra, share with us your knowledge about using the two different kinds of mechanisms to minimize the 6% estate tax.
Yes, of course. So there's actually various ways where you can minimize the impact of the 6% estate tax if you do proper estate planning. So some of the mechanisms that we use are trusts, donations, and life insurance. Maybe we can go first with the trust, and then we'll discuss the donations and the life insurance. So for trusts, there are various types of trusts, but we can categorize them to either revocable or irrevocable trusts.
Right.
So for revocable trusts, the transfer is still going to be subject to 6% estate tax because the transfer of ownership is upon the death of the grantor. So once he dies, the property is transferred to the beneficiary. But the 6% will be based on the value of the property at the time of his death. It's presumptively higher than what would be the value of the property if you transferred it at the time that he was still alive.
Yeah.
Right? And in the case of irrevocable trusts, on the other hand, the property is already transferred at the time that the property is placed in the trust. The taxes due there would be based on the value of the property at the time that it was transferred, which is going to be considerably less than what the value of the property would be at the time that the grantor passes away later on.
So you're saying that the way to reduce or minimize the 6% estate tax is to set up a trust, an irrevocable trust, in the lifetime of the client,
Yes,
such that he will need to pay the 6% upfront now, but it's at a lower price point because properties, let's say he passed on 10 years later.
yes.
Then if you were to leave it to 6% in 10 years later, the property may have doubled or tripled.
Yes, that's correct. That's exactly it. So what we're trying to do here is we're trying to avoid having the heirs, or the beneficiary in this case, pay a higher amount later on at the time of the grantor's death. So actually, irrevocable trusts are a good way to protect the assets and whoever will be the named beneficiary from creditors who are claiming anything from the estate. And it's also ideal, it's actually very ideal for properties that have high value, like real properties, as you mentioned, because it only appreciates over time. And also for high value stocks. As we know, stocks would fluctuate, but if it's a stock that's performing well, then over a span of maybe 5 or 10 years, by the time the grantor dies, it would have only appreciated its value.
So does it make sense to do the transfer into the trust, the stocks and shares, during a market downturn, where the shares have plummeted 50%?
That would actually be good as well. And you have a much lower price point.
So there is still financial planning to be done even in a market downturn. That's awesome.
Maybe something also to consider, other than the value of the properties, is the maintenance fees. There are some who are concerned with the continuous payments that they need to make to have the trust either established or to have it continue or ongoing, right?
Yeah.
So I guess the analysis that needs to go here is whether you're willing to pay continually the maintenance fees, or are you more willing to settle a higher amount of estate taxes later on.
Understand. So it's a judgment call, right? I would say that for clients who have assets that are going to appreciate aggressively, then it makes more sense to consider the usage of trust to lock in that estate duty, so to speak.
Yes, just to lock in the value of the property. And actually it can also act as additional protection. Additional protection for the heirs. And if you do establish a trust that's a business, or if you put up a holding company and then you put it in the trust and the company is continuously earning, then your beneficiary has all of the proceeds. So it's also a wealth growth vehicle. It's not just estate planning.
Exactly. So the trust has much more usage than just minimizing taxes, but for creditor protection, for estate planning, for wealth distribution across generations. Now, what about the second part about donations? That is very interesting. How does that work out?
So donations basically in the Philippines are like gifts. They're considered as gifts in the Philippines. How do you circumvent basically the 6% estate tax? So Honestly, the circumvention is more apparent when you donate real estate properties or shareholdings, or those properties that appreciates over time. Tax rate is the same, but the tax base would be the current market value of the property, which, if transferred during the life of the decedent, is arguably lower than its value upon his death.
So in other words, the donation is something like a gift tax in the US where they give it in their lifetime.
Yes, right.
And you lock in the value now, such
Yes.
that when death occurs a few years later, at a higher price point, your beneficiaries need not, your estate is not subjected to that.
Right.
There's a cap, right? Is that you mentioned earlier? There's a cap.
It's not really a cap. There is basically an exemption. You can donate every year, right? So every calendar year, you have basically an exempt amount, which is 250,000 pesos, roughly around $4,000, $5,000.
Okay.
So in excess of that gifts, that would only be subjected to the 6% donor's tax.
So in other words, for a client who is approaching maybe retirement or his estate planning, he can actually donate so to anybody in the first about 4,000 or 5,000 USD.
Right.
That will not attract the 6%.
Yes, correct.
So if he prepares for legacy, he can actually give maybe 5,000 every year for the next 10 years, and 50,000 will be accepted.
If they're already setting up for a legacy, as long as it does not impugn the legitime, basically, because of course they would still see this. So if you've donated a substantial amount to the point that you've already given your estate to for a third person, a stranger, then they would the BIR or the Bureau of Internal Revenue would still check on this. They could still cancel the donation at the end. As long as it does not impugn the legitime, you could freely give this away already.
Right. So we have talked about setting up of a trust for a client who wants to minimize and to do a better tax plan, right? The second one is in terms of gift, like donations. And coming to the last one, insurance policies. So how can one use insurance policies to minimize estate taxes in the Philippines?
Right. So in the Philippines, life insurance can be procured by the decedent during his lifetime and designate one of his heirs or some of his heirs as his beneficiary. In the Philippines, you could put either the beneficiary to be a revocable nomination or an irrevocable nomination. This is more apparent for irrevocable nominations. So upon the death, the proceeds of the insurance will go directly to the beneficiary and will not form part already of the estate, thus circumventing the 6% estate tax. Also, life insurance policies or the proceeds of life insurance is not considered income. So there is no other taxes to be paid.
Just to put things in simpler form, you're saying that for a client who is planning for estate planning, let's say he has $1 million USD, okay? So he puts the $1 million USD into a financial product from an insurance company, and he needs to make sure he does an irrevocable nomination to maybe his daughter.
Yes.
And upon his demise, the daughter will receive, being the nominee, will receive the $1 million at no estate duty, no estate tax, and there's no income tax that the daughter has to pay. And that $1 million is totally tax-free.
Exactly.
Just by using a financial instrument like an insurance product.
Right. Correct.
Wow. So insurance is actually a very good tool in estate planning in the Philippines, right?
Yes, it's not only the individual. Corporations can also purchase insurance policies and use its directors as beneficiaries. This would also be a good vehicle to have the shares just within the pool of the corporation and to not any other third person come in.
So just in case, some of the people who are watching this may ask, what kind of policies? Is there a requirement it must be policies with cash value? Can it be a policy that is bought overseas? Would you want to have any input to that?
Any generic policy would do. Even those that are overseas are also acceptable. Life insurance policies, trust policies, as long as they are basically insurance or they insure a life or property. This would already circumvent the 6% estate tax. It would not form part of the gross estate, nor would it be income when
Okay.
it comes to the distribution of the proceeds.
Basically, tax-free, right?
Mhm.
Wow, thank you so much. I mean, we have learned so much in terms of how the Philippines law in terms of taxation, yes, estate tax to be exact, and what are some of the ways that we can actually help our clients to minimize or to even do further better tax planning. But every client is very different, right? Some of them, they have very unique circumstances depending on where they live, what kind of assets they have. So if let's say the audience would like to take it further, they have clients who really, really need help. Can they contact you guys? Can they contact Corp Law to help their clients? That how does it go? Is that based on a consultation basis?
They can reach out to our law firm directly. We do have an email if they would prefer email. We do also have a mobile number. It might not be ideal for clients who are residing outside the Philippines, so I think sending us an email would be better.
Okay, and then after that, they can arrange a consultation with either one of you to advise them, right?
Yes.
Perfect. Thank you so much, Danny and Zendra. I believe that this has been a very informative session, and we look forward to see you again. And hopefully, any one of you who are listening in, if you have clients, whether they are Filipinos or ex-Filipinos, they really need help in their tax planning, estate planning, inheritance succession planning, business owners who have assets in the Philippines, you know what? You should really hit Corp Law, hit Danny and Zendra up because they are the best people you should talk to. Thank you so much for coming in today. With that, we're going to end the session. Thanks once again, Danny and Zendra. All the best.